All right, let's proceed.
Good morning, Mr. Chief Justice, members of the court. My name is Robert Hennessy. I'm here on behalf of appellant Alexis Batista. With me at council table is attorney John Thompson, also from my firm. We're here today on what is essentially the Commonwealth sentencing appeal brought pursuant to Chapter 211, Section 3. My client is seeking reversal of this single justice's order demanding that the enhanced penalty of community parole supervision for life be imposed upon him. Now, this is really, I think, a simple case. The foundational premise on which the Commonwealth builds its appeal is that the sentence imposed in this case was unlawful for failing to include community parole supervision for life. However, that premise is completely undermined by three simple facts in the record. First, Mr. Batista was never lawfully charged with the facts that might give rise to community parole supervision for life. Second, the record is clear that Mr. Batista at no point admitted or pled guilty to such facts during his colloquy. And third, under Pagan and Cately, given the previous facts, community parole supervision for life simply could not be imposed upon him.
Can I ask you a question? Did the Commonwealth also suggest that the sentence was illegal because it was 1 month as opposed to 6?
The Commonwealth did not suggest that at all. That was suggested by the single justice who noted in her opinion that the Commonwealth hadn't raised the point. And in fact, in their briefing before this court, the Commonwealth again says they didn't bring that, they neither objected to that portion of the sentence nor argued it to the single justice.
Well, suppose we decide you're right about the community, the lifetime community paroles portion.
Yes.
The sentence remains wrong as to the amount of time.
The sentence remains inconsistent with what the statute requires. The statute requires either no, it doesn't require incarcerated portion at all. But if one is imposed, the statute would seem to say that 6 months was required if it was going to be imposed.
It says shall be punished by imprisonment.
By fine or imprisonment, I believe.
First conviction of this subsection shall be punished by imprisonment or by a fine. I see what you're saying.
Yes. So
or by
I believe
both
that
fine and imprisonment.
Imprisonment
Okay.
is not required, but it would seem to suggest that if it is imposed, it would have to be 6 months.
So probation could have been imposed.
Probation could have, a suspended sentence could have been imposed, but, or a time served. If what was imposed in this case was 30 days time served, because he had served a year prior to that.
And let me ask you about the time served. The time he was serving, was that for a parole violation or a probation violation?
That was for a parole violation.
And how does he get time?
Oh, excuse me. I'm sorry, Your Honor. That was for a probation violation.
And was it violation of probation for the very same conduct that he was being charged with?
No, it was for the underlying crime that he had been placed on, for which he had gotten a registry requirement, the underlying sex crime, which put him onto the sex offender registry to begin with.
So the sentence he got for that underlying sex crime was 3 to 5 or something, plus probation on and after?
Yes, I
He
believe.
was in a probation violation.
Yes, I believe so. Your
So
Honor.
how would he get credit for that, since he was not serving time awaiting trial on this case?
That is a good question. That's not one that had come up earlier in the litigation, but I guess the question would be whether or not it was within the court's discretion to have time served under those circumstances, and I would have to defer my answer on that because it's not a question that I had, honestly.
So what is your view as to what, I know that you want the CPSL to be knocked out, but what do you say precisely should be the order of this court?
I think that the order of this court should be reversing the single justice's order.
Okay,
and doing nothing else. I don't.
But how do we affirm the judge's order where it appears to be inconsistent with the statute because he opposed 30 days time served where it's either no time or 6 months?
Well, as the single justice's memorandum suggests, I think that this is a case for waiver on the part of the Commonwealth. They neither objected to that portion of the sentence, nor did they raise it before the single justice. So I think this court would be well within its authority to reverse without addressing that issue that has never been raised.
Aren't you a bit uneasy about arguing waiver when they are?
I am, in this situation, no, because
Because you're saying that they have an illegal sentence should stand because a party failed to object, and in a moment, your sister is going to stand up there and say an illegal sentence should stand because your client failed to object.
True. However, the difference is that it was the Commonwealth that was the appealing party. What my argument is that there was no error made at trial, that there was a non-CPSL offense charged, a non-CPSL offense pled guilty to, and a non-CPSL sentence imposed. Therefore, there is no procedural default vis-a-vis the defendant in this case. The earliest point that he could have raised this issue was before the single justice, because nothing from the point of view of the defendant had gone wrong at the trial. So factually, it's strictly in terms of a procedural default, it is different, because the Commonwealth is the appealing party in this case. So I would say that that is a distinction that makes a difference.
Sometimes when, in many cases where we vacate part of the sentence because it's inappropriate, we remand it for resentencing because the judge's conception of the package in which the sentence was imposed needs to be refigured or reconfigured by the judge. Why shouldn't we send this case back simply for resentencing?
Well, number one, Your Honor, I believe that, and I believe this comes from this Court's decision in Woodward, that when you're dealing with resentencing, a Commonwealth sentencing appeal, and you're remanding for resentencing, there are serious double jeopardy implications to that act, just generally. Woodward says that there's only really been one instance in which resentencing at the behest of the Commonwealth has been recognized, and that is when a Rule 29 motion to revise and revoke has been granted. The Commonwealth then has power to go and request that that sentence be reinstated. However, because there is no statute that allows the Commonwealth a sentencing appeal in any criminal case outside of those really narrow constraints, the only way that you could not violate double jeopardy, and this is coming from Woodward, is if the sentence itself was unlawful.
But why couldn't we order resentencing with direction that the new sentence not be greater than the old?
You could do that. However, the only way that that could be enforceable at this point is to have no sentence at all, because you have a 30-day sentence. And if what would theoretically make this sentence lawful would be to increase that to 6 months, there is no way to remand without it increasing the sentence. You could remand and say, 30 days was an unlawful sentence, so you have to fine this person.
Right. Could you do that? Just fine?
I think you.
Because that's within the contemplation of the statute, as you pointed out.
That is within the contemplation of the statute, and I think that that would be possible. I think that it may still raise a double jeopardy issue, but actually, no. I'm sorry. I'm going to withdraw that. No, I think that would be fine to impose a fine at this point. So that essentially is my argument. I can go into the waiver analysis if the court would like. The contrary argument in this case is obviously that the defendant somehow waived his rights in this case. Go ahead.
This was a plea, right?
Yes, it is.
And the defendant was arguing for 30 days and no CPSL.
Correct.
And the Commonwealth was arguing for 60 days and CPSL.
I believe they were arguing for 6 months in CPSL.
I'm sorry, 6 months. 6 months in CPSL. So if it were to be remanded, would the defendant have the option of withdrawing his plea?
If it were to be remanded for the imposition of CPSL, I believe under Rule 12C he would have the option to withdraw his plea. And that was put into the single justice's order as an option. Yes.
But of course, if he could withdraw his plea, then the Commonwealth could supersede the complaint.
Yes, it could. It could either try to amend the complaint, which might have its own issues, or it could withdraw the complaint and recomplain the case. But I think either of those would violate double jeopardy in this case. So, I guess in summation, I think that the single justice clearly erred in imposing CPSL, where the facts for that sentence were neither charged nor proven, at the colloquy. Charged in the complaint or proven at the colloquy. I see my time is up.
Thank you, sir.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Amanda Teo on behalf of the Commonwealth. Your Honors, I'm asking that this Court affirm the single justice's order vacating Judge Gobern's sentence and remanding to the municipal court for either resentencing according to the statute or for the defendant to withdraw his plea. Here, the question is whether the judge was required to sentence to CPSL, whether that was the lawful sentence, where the complaint, however imperfect, put the defendant on notice that he was being charged under 178A1 and A3. The defendant did, in fact, make various defense counsel, in fact, made various statements indicating the defendant was, in fact, aware that he was subject to CPSL, and the defendant then pled guilty. See, that's the question that's before this
No, I'm
Court.
sorry, are you asking us to revisit Cately?
Not at all, Your Honor.
So don't you agree that under Cately it was an unconstitutional sentence?
Your Honor, I believe that this was definitely by no means a model complaint, and it was deficient under Cately.
It was deficient in the very same way that the Cately complaint was deficient.
I would suggest that, yes, Cately requires that a complaint charging 178A1 allege specifically that this particular defendant committed a predicate offense that would trigger CPSL. This complaint, however, was not as deficient as Cately, and we know this for two reasons.
Okay, well, the question is not whether it was as deficient as Cately. The question is, did it include in the complaint the required allegation in Cately?
I understand, Your Honor, but I would submit that this complaint was adequate in the sense that, first of all, in Cately, the only mention of CPSL was embedded in a penalty parenthetical attached to only one paragraph of the complaint which charged the underlying offense. In this case, we have three separate paragraphs, each of them laying out a different portion of the statute. Secondly, in Cately, that allusion to CPSL in the penalty parenthetical did not even mention A1 or A3, and in fact would have encompassed a charge under A2, which the defendant in Cately and the defendant here were not charged under. Whereas this complaint was very clear that A1 and A3 was what was being charged. So I would agree that this complaint was deficient under Cately. I think this complaint puts the defendant on notice that he was, in fact, being charged under A1 and A3. And we know that for a fact because the defendant at the colloquy made very clear that his objective was to avoid CPSL. If he had no notice that he was even subject to CPSL, then that it wouldn't have made sense for defense counsel to have made that the cornerstone of his argument during the plea colloquy. We also know that the defendant had notice that he was subject to CPSL because the Commonwealth iterated a number of times during the colloquy that he was convicted of rape of a child. He was convicted of 2 counts of rape of a child in Barnstable, and that CPSL was thus mandatory under the statute. And so, however imperfect this complaint was, this defendant did in fact have notice that he was being charged under A1 and A3, and for that reason, it puts him in a very different position than the defendant in Cately, even though—
But now you've confused me, because I don't recall anywhere in your brief you arguing that this complaint passes muster under Cately.
I'm not asserting that this complaint passes
Okay,
muster.
so it would be unconstitutional under Cately to have imposed CPSL based on this complaint.
I do not agree with that proposition, Your Honor.
How do you have it both
this
ways?
reason. Well, because the cornerstone of an Article 12 analysis and whether a complaint passes muster is whether the defendant was in fact on notice that he was subject to a certain offense and subject to certain jeopardy. And here, that's the case, whereas in Cately, that was not the case. So I do think that he's in a very different position. This defendant had notice that he was being charged under A1 and A3, and that CPSL was thus required, or at the very least, he was subject to CPSL. And that puts him in a very different position than the
Then
complainant
Cately
in
doesn't
Cately.
control.
I'm suggesting that Cately is beside the point, Your Honor.
Did you argue that before the single justice?
Yes, I did. That is the cornerstone of the defendant's of the Commonwealth's argument, both before the single justice and here before this court, that Cately is besides the
It's not in
point.
your brief here. I thought your brief was that there had been a waiver of that Cately otherwise applies, but here there was a failure to raise the issue at the time of the plea, and therefore it was waived, that the defect was waived.
Your Honor, it's a two-pronged argument. First, Kately is besides the point because it was waived. But also, this is not the same situation as Kately. And I argue that you'll see in our brief, we say that this defendant had noticed, and that's precisely what the single justice found.
Well, the defendant in Kately had noticed, too. There was the provision, I mean, the complaint in Kately made reference to the fact that certain people get mandatory sentences. I mean, that too was included in the Kately complaint, was it not?
It was alluded to in the complaint by means of a parenthetical that discussed penalty, but A1 and A3 were never specifically alleged in Kately. Regardless, Your Honors, let's move on to the waiver argument then. Even if this complaint was deficient under Kately, and I can see that it is, and in fact, this hopefully is no longer the computer-generated complaint that is issued by the clerk's office for a charge of failure to register. I know the Commonwealth has been working with the clerk's office to change the language that gets issued from the computer. Even if this complaint was deficient, Kately is beside the point because this particular defendant, unlike the defendant in Kately, chose to plea. The defendant in Kately went to trial. The defendant in Kately asked for a bill of particulars, and the defendant in Kately filed a motion challenging the language of the complaint prior to sentencing. This defendant, however, did none of those three things.
And why should, I mean, this complaint did make a proper allegation of a failure to register, did it not? It stated a crime.
Absolutely, Your Honor.
So why was it simply did not state the language that would permit the enhanced penalty of CPSL?
Assuming that's the construction of this complaint, then that would be. I mean, I think I would take issue with the construction of that complaint in that way. I would suggest that this complaint did in fact lay out those three paragraphs, and that this defendant.
But let's assume that it. Well, let's assume for the moment that it's defective in failing specifically to say. This defendant, having been convicted of the crime of, I think, indecent A and B of a child, did commit the following offense. Okay, it didn't do that.
Right.
Okay, but it did say he as a sex offender, he failed to register. That's a crime. It just is a crime which doesn't get you CPSL.
Your Honor, that's correct. It does state a crime, and it also states.
Why is it defective? I mean, let me ask another question. I assume all the time as a DA, you may have somebody with prior convictions, which, if alleged in a complaint or an indictment, would trigger an enhanced penalty.
That's correct, Your Honor.
And often, as a result of a plea, you say, we will not charge this defendant with the enhanced part of the sentence. We'll simply charge him with the non-enhanced part of the sentence. And the person, although they have those prior convictions, is pleading guilty to a crime which does not include the enhancement. Is that a defective complaint? Because the person indeed has those convictions, but it's not alleged in the complaint or the indictment. Does that make it defective?
Certainly, if in that situation, if the complaint only charges the underlying crime and does not at all charge the indictments, then yes, then that defendant can only plead to what is well charged in the complaint.
Okay, but that's not my question. My question is it a defective complaint because it fails to make the allegation, which is true, but not included in the complaint or the indictment? Does that render it defective?
I would say it is a defective or imperfect complaint, but it was adequate to put him on notice.
So if a person is charged with unarmed robbery and he used a gun, the person's on notice that they could be convicted of armed robbery.
No, Your Honor, I'm not suggesting that. I'm saying if this court does in fact find that the complaint was, however imperfect, it was adequate, and that he did in fact tender an intelligent plea, then CPSL would be the mandatory sentence. If this court disagrees with that proposition, then I'm back at square zero.
So you're saying that a defendant has to, at a plea, say, Your Honor, they didn't charge me with the language that would require an enhancement, and I'm complaining about that. I'm complaining to the court because they didn't charge me with the more serious crime with an enhancement, and if I don't complain about it, the judge can impose the enhanced penalty?
I'm saying, Your Honor, that in this circumstance, this is pre-Kately, everyone at the plea colloquy, with the exception of maybe the plea judge, understood that this defendant was being charged under A1 and A3, and that he had, in fact, committed those predicate offenses and was thus mandated to CPSL, or subject, at least, to CPSL. That's the scenario that we have here. If it were a defendant who was in various different circumstances, then my argument would be
And the
different.
defendant was supposed to argue what to the judge? The judge was basically going to say, I am going to only ask you to make the admissions required for the failure to register. And what's the defendant supposed to do? I object, Your Honor. I'm not quite sure how he would avoid the waiver which you say he did.
He would have avoided it by asking for a bill of particulars if he was really confused. But the fact is, he was not confused, Your Honor. I think that's where.
So, but you said he waived, so that means he's supposed to do something. So what's he supposed to do?
If he was actually unclear, which he was not in this situation, as to whether or not he was subject to CPSL, then he would have asked for a bill of particulars.
You're really suggesting that they fix the complaint so he could get the punishment that he got. That wouldn't really be in his counsel's best interest, in the client's best interest to do, right?
I'm saying
This defective complaint as to which I'm about to plead so that you can make sure that I will be subject to the punishment that you're giving me.
I think setting aside my basic point, which is that everyone during the colloquy understood what this complaint charged, I would say yes. And I think this court's jurisprudence regarding waiver by plea reflects that, because both waiver by plea and waiver in the context of bringing forth any challenge to the language of a complaint or indictment prior to trial or the entry of plea. This court's jurisprudence has always reflected that if you are unclear as to what you're being charged with, if that is your argument, then you have to bring it before the plea, because that gives all parties an opportunity to clarify, and it allows the Commonwealth to take out a new plea and issue a new it allows the Commonwealth to issue a new complaint and no process the old one if it's not clear, or it allows the Commonwealth to put forth a bill of particulars that would allow the defendant notice under Article 12. That has been the jurisprudence of this court, and I suggest that the jurisprudence makes sense. I think all litigants have a responsibility to make sure that all litigants have all defendants have a responsibility, if they are not clear as to what's being charged, to ask the court, to ask the defendant, to ask the Commonwealth to file a bill of particulars.
Counsel, your time is up.
Thank you, Your Honors.
Thank you very much.
All right. Hear ye, hear ye.